Good day, ma'am. I'm Maria May Pabrua, and we are the quiet ones. So today we are going to report the lesson 3, which is the dissolution of a corporation. So first, this presentation focuses on the legal process for ending a corporation's existence under the revised corporation code. So first, what is dissolution? So according to section 133, dissolution it is the extinguishment of the franchise of the corporation. So if the corporation sell all the asset, liabilities, and the deposit account, it does not automatically dissolve. Only the SEC have the power to revoke the corporate franchise specified by law. For example, Bank A sell all the asset, liabilities, and the deposit account to Bank B. So it does not automatically dissolve. Bank E is still empty, but a corporation still exists. Is still a corporation. So to formally dissolve a corporation, only the SEC have the power to revoke a corporation. So according to section 133, they have two ways of methods of dissolution. First is voluntary dissolution and involuntary dissolution. So what is voluntary dissolution? So it is initiated by corporations itself, while the involuntary dissolution, it is initiated by the SEC for causes specified by law. So in my part, I'm going to discuss what is dissolution, that no creditors affected. So voluntary dissolution, no creditors affected. In section 134, that the condition that dissolution must not prejudice the right of any creditors. So having a claims against a corporation. So then for the approval process, they are going to vote by a majority vote of the board of directors or trustees. So how we can identify how many vote they need? So if a corporation have a members or shares, 1,000 shares or members, we are going to times and 2 divide 3 equals 0.667. So 1,000 shares of members times 0.667 equals 667 vote. So for the procedure for voluntary dissolutions, no creditors affected. The law requires a formal notification process before the final vote to dissolution a corporation. Final vote to dissolve a corporation. So first, a 20 days advance notice must send to all stockholders, either personal or by mail. Second, the notice must clearly state that the purpose to vote on dissolution. So finally, for the sake of public transparency, the corporation must publish a notice in a newspaper at least once before the meeting date. This ensures that the public and all stakeholders are fully aware of the intent to close the company. So these are the procedure for voluntary dissolutions to know that no creditors are affected. So for the requirements for submission to the SEC, so the corporation must state why it is closing, or what are the what are the reason for dissolution of a corporations? So the SEC must need proof that the corporation followed the procedure or the 20-day rule. So the second the requirements for submission to the SEC. So the SEC requires a record of who voted yes, involve a list of the directors and the stockholders showing that the majority vote required was actually met. So this provide the logistical proof of the meeting. It confirms that a formal gathering actually took place where the dissolution was discussed and received upon. So, since the law requires a public notice in a newspaper, you must provide the details of the publication. So, in the screen, these are the requirements of for the submission to the SEC. So, once the SEC receive and approve these requirements, the corporation is officially dissolved. So, I'm done with my part for the voluntary dissolution. No creditors affected. So, in the next reporters, so Berse are going to report the voluntary dissolutions where our creditors are affected.
Voluntary dissolution where creditors are affected, procedure and contents of petition. So, according to Section 135, where the dissolution of a corporation may prejudice the rights of any creditors, a verified petition for dissolution shall be filed with the SEC. So, the company must file a petition for dissolution with the SEC or Securities of Exchange Commission. This is required because closing the business may affect people or companies it owes money to. So the decision must be approved by the majority of board of directors and trustees. At least 2 out of 3 of the stockholders or members. So the petition must include all claims and debts of the corporation. In short, the company cannot just close, it must follow a legal process to protect the creditors. So next is voluntary dissolution where creditors are affected. Procedure and contents of petition. So, the petition must contain all claims and debts against the company, the reason why the company wants to dissolve, how and when the notice was given, the date, place, and time of voting. So, it must also submit it to the SEC, a certified copy of dissolution approval, and all the list of the creditors. So in short, the SEC needs a full details of it to make sure everything is fair and legal. Third one is the dissolution of shortening corporate term. So under Section 136, a voluntary dissolution may affected the amending articles of incorporation to shorten the corporate form pursuant to the provision of the RCC. So, dissolution by shortening corporate term. So, a company can dissolve by shortening its corporate lifespan, amending of articles of corporation. This amendment must be submitted to the SEC once the new or shorter term ends the corporation is automatically dissolved. So important point, no need for a separate dissolution approval. The expiration itself ends the company. So withdrawal, lastly is the withdrawal of request and petition for dissolution. So section 137 provides the withdrawal of the request of dissolution must be written, duly verified of an incorporator, director, trustees, shareholders, or members, and signed by the same number of incorporators. So, withdrawal of request of dissolution. The corporation can withdraw its request for dissolution. So, the withdrawal must be in written, be signed by the same group, approved for dissolution. So, kung kinsa tong nagpirma tong kuan pag dissolution, sila po na mo pirma balik para withdraw ang ilang gifile nga petition. So it must be submitted within 15 days after filing the dissolution request. So in short, the company has a chance to stop the process but only within a limited time. So overall, this is all about how we protect our creditors and how to close the corporation in legal ways and fair.
Involuntarily dissolution. This happens when a corporation is forced to close by the SEC or the court even if the owners don't want to. It usually occurs when the company violates laws or fails to operate properly. Example, a company registered but does not start any business within 5 years, it can be dissolved. Second, a business stops operating and becomes inactive for 5 consecutive years, the SEC may dissolve it. Third, a company involved in any illegal activities like money laundering, tax evasion, it may shut down. Grounds for involuntarily dissolution. 1. A company created for illegal purpose. Example, a fake company is created just to hide money from illegal activities. Second, company commits illegal acts and owners knows it. Example, if a company is involved in smuggling goods and the owners knows but did nothing. Third, a company tolerates illegal acts. Example, manager keeps allowing the company for corrupt practices like bribery and the company ignores it. That will be an example for a ground of involuntarily dissolution. Next is the corporate liquidation. After a company is dissolved, liquidation happens, like selling company assets, equipment, or property, turning them into a cash, paying debts. Example is a closed restaurant sell its tablets, kitchen equipment, and appliances to pay for the remaining debts. Next is the 3 methods of corporate liquidation. Number 1, by the corporation itself. Example, a small company decides to close. The board sells company assets, pay debts, and distribute the remaining money to shareholders. Second, by trustees. Example, a company assigned a lawyer for a financial expert as trustees. That person sells assets, pays creditors, and distribute the remaining funds. Third, by a management committee and receiver.
Example, a corporation is in serious financial trouble and or involves in illegal issues. The SEC appoints a receiver to control the company and liquidates its assets properly. Next is special rules and exemptions. Number 1, exemption rules. 2, banks exemptions. 3 is treatment. Exemption rules examples is a company appoints a trustees in its 3rd year. Liquidation can continue beyond 3 years limits. Bank exemption. If a bank closes, it is handled by the Bangko Sentral and the PDIC, not the usual corporate process. Escheatment. A shareholder cannot be located after liquidation. Their money is turned over to the national government. And that's all for the involuntarily dissolution. Next reporter will be to Miss Dinglasa.
So, foreign corporations. First is definitions. Form organized exists under law other than Philippines. So this means the company was created another country, not in the Philippines. So the second one is license requirements. Must obtain a license permit and certificate of authority to transact business locally. So before operating in the business Philippines, the company must first get official permissions, license, and certificate from the government. So the third one is legal standing and license. Legal standing and license parade. Corporations cannot sue in the Philippine court tribunals, but may be used on the ballot causes of actions. If the company has no license, it cannot file a case in court. So, however, other people or companies can still file case against it. So next is resident agent and service of process. So resident agent, section 144. Mandatory of license insurance. Foreign corporations must have residence agent to get a license. Individual residing in PH good moral financial standing. So if the agent can be person living in the Philippines with good reputations in financial status, that's individual residing in PH good moral financial standing. So next is domestic corporations, lawfully doing business good standing with SEC. It can also be a Philippine company that is legally operating the registered with SEC. The next is partnerships. A partnership like a law firm, accounting firm can also be assigned as the agent. So next is service of process. Section 145. Foreign corps must designate a resident agent to receive legal notice. So this is the company must assign someone to receive our papers and legal documents. Next is if no agent service may be made on the SEC, which transmit it to the corporations. If there is no agent, the SEC will be receive documents and send them to the company. So next is amendments, merger consolidations. So amendments, section 147 to 148. File amended articles by laws with SEC within 60 days of effectiveness. So any changes in rule or structure must be reported to SEC within 60 days. So second is name change or new business purposes requires an amended license. So if the company changes in its name or business activity, it must update its license. And next is merger consolidation, section 149. So licensed foreign corps may merge consolidate with domestic other foreign corps. If permitted, they can combine with other companies if allowed by Philippine and home country laws. So next is file documents with SEC within 60 days. After merging, they must submit the required papers to the SEC within 60 days. Absorbed foreign corps must file a license withdrawal petitions. If company is absorbed no longer exists separately, it must cancel its license. So number 4 is doing business without license and exception, section 150. No foreign corps may transact business without a license, so they cannot operate legally without permission. And next is nor maintain, intervene in legal actions. So they cannot join or, for example, they cannot join or continue court cases. So next exemption to inability to sue isolated transactions. Stop if the other party benefit it just one-time deal. Just one-time deal. They may still sue, especially if the other party already benefit. So independent causes actions, protecting trademarks, defending against lawsuits. So they can go to court, protect their rights or defend themselves. So unlicensed but non-operating corps may sue to protect intellectual property. Even without license, they can file cases to protect things like trademarks or patents. So the next is withdrawal and foreign investments. Act Withdrawal Section 153. File competitions with SEC, the company must formally apply to stop operating. So the second is require settled claims, paid taxes, penalty. So all debts and taxes must be fully paid. Weekly publication for 3 weeks. The withdrawal must be publicly announced for 3 weeks. So next is Foreign Investments Act of 1991. Doing business require registrations. SEC for corps partnerships, DTI for sole props. Any business activity must be registered with a proper government agency. So foreign investors may own 100% equity except for the areas of the FINL. So which means, for example, foreigners can fully own business unless it is restricted. So next is limited ownership of defense, health, small enterprises. Some industries limit foreign ownership to 40% or restrict it for national security or small business protection. License, revocations, and investor rights. Revocation, suspension, section 151. Failure to file reports. If the company does not submit required reports. So that's next is maintain a resident agent. If it does not keep a resident agent pay taxes, and if it fails to pay taxes, comply with license terms. So next is for example is if it violates rules, of its license. Next is special laws and grounds. It means insolvency of banks. So it does not keep a resident agent pay taxes, and if it fails to pay taxes, comply with license terms. So next is if it so for example is if it violates rules of its license. Next is special laws and grounds. It means insolvency of banks. So other laws may add more reasons for consolations. So investor rights. Reputations of liquidations proceed earnings in original currency. So investors can send their profits back to their country in the same currency. So next is protections against explorations, requisitions with just compensations. So the government cannot take their property without fair payment. So last one is free transfer of funds and equal treatment of foreign local investors. So example, they can move money freely and must be treated fairly the Filipino investors. So next reporter is Mark Francisco.
Today, I will be discussing Lesson 5, which focusing on SIC investigation, power, sanction, and other important provision under the revised Corporation Code. So, start from Lesson 5.1, Investigation and SIC powers. Let's start with SIC investigation under Section 154. The Security and Exchange Commission, or SIC, has the authority to investigate violation of the law. They can examine corporations and even publish their findings, but this must follow Data Privacy Act. Now, for SIC powers, the SIC can administer oaths, issues, subpoenas, and take testimonies. This means they can require people to appear and provide evidence. They can also issue case and disease orders. These orders can temporarily stop illegal activities for 20 days, and may become permanent after a proper hearing. In addition, the SIC can hold non-compliant parties in contempt and impose fines which can go up to 30,000 pesos plus daily penalties. Next is administrative sanction and penalties. Moving on the administrative sanction under Section 158, the SIC can impose fines ranging from 5,000 pesos to 2 million pesos. They may also issue case and disease orders, suspend or revoke licenses, or even dissolve a corporation if necessary. Some key offenses include unauthorized use of the corporate name, which can result in fines for 10,000 to 200,000 pesos. Fraudulent business conduct, which can go as high as 2 million pesos or more if it harmed the public. Corruption-related offenses may reach up to 5 million pesos fines. And retaliation against whistleblowers can also result in serious penalties. Lesson 5.2, Miscellaneous provisions. First, let's define outstanding capital stock. This refers to shares that have already been issued, including treasury shares. The National Economic and Development Authority, or NEDA, plays as a role in monitoring corporations to ensure they follow the law. They also recommend ownership limits to prevent unfair competition. Corporations are also required to submit annual reports and certified financial statement to the SIC. They ensure transparency and accountability. SIC power and intra-corporate controversies. The SIC also has visitorial powers. This means they can inspect company records, supervise operation, and ensure compliance. If a corporation refuses to cooperate, it may face penalties such as license revocation. Intra-corporate controversies refers to dispute between stockholders, members of officers, or between corporation and the government. These cases are handled by a region trial court, although the SIC still has supervisory authority. Even if a corporation is dissolved, its rights and liability do not disappear immediately. Electronic filing arbitration. Under Section 180, the SIC is required to develop the electronic filing system. This allows companies to register and submit documents online. Section 181 discusses arbitration. Corporation may include arbitration clauses in their rules so dispute can be settled outside the court, except for criminal cases or issues involving third parties. Special regulators and post-dissolution rights. Lastly, under Section 183, especially regulator like the Bangko Sentral ng Pilipinas and the Insurance Communication still have authority over banks and financial institutions. And under Section 184, even after corporation is dissolved, the rights and obligation of the corporation, its stockholders, and officers still remain. The SIC plays a vital role in regulating corporation by investigating violations, enforcing rule, and ensuring fairness and transparency in business operation. That it's all. Thank you. Thank you.
The relevance of the lessons of the corporate dissolutions is it is important to be knowledgeable about the dissolutions of our corporations, so that as a stockholder or one of its directors, we will know his right and obligation in case the corporation is dissolved. So the lesson summary is the dissolution of a corporation is the extinguishment of the franchise of a corporation and the terminations of its corporate existence. Second, the dissolutions of a corporations may be voluntary or involuntary. Third, there is a 3-year winding up period for the corporations to continue as a body corporate for the purpose of settling and closing its affair. So that's the relevance of the lesson and the lesson summary of the corporation of the dissolutions of corporations.
Ready? Feel the beat. Let's move. 3, 2, 1, go. Chop. Chop. Walk. Walk. Excellent. Keep going. Knock. Knock. Catch your breath. Stay with me. Ready? Go. Pull. Pull. Snap. Snap. Wave. Wave. Ride.